Hello, my name is Phillip Hundl. I handle condemnation cases for landowners throughout the Gulf Coast area of Texas. I'd like to talk today about fee arrangements in condemnation cases. So uh, there's been some questions about what's the typical fee arrangement for a landowner that's faced with a condemnation case, be it a pipeline, be it a road expansion, utility easement. What options are available for that landowner? I think sometimes landowners believe that to hire a lawyer, it's going to cost a lot of money. It's going to be billed on an hourly basis, and that's going to eat into whatever possible compensation that they will get from, in this case, let's say a pipeline company. And so landowners tend to sometimes be hesitant to get a lawyer involved, especially get a lawyer involved early on, because they're afraid they're going to receive less from the pipeline company in the end because they have to pay for their lawyer. I understand that concern, and so let's talk about the typical fee arrangements in a condemnation case. Typically, condemnation attorneys handling landowner condemnation matters will handle those matters on a contingency fee basis. What does that mean? Let's just say, for example, a landowner receives an offer from a pipeline company of $50,000. By hiring an attorney on a contingency fee basis, the landowner in the end receives $80,000 through the negotiation of the attorney, possibly negotiation and reaching a settlement or representing the landowner at a special commissioner's hearing or all the way through trial, and receives more. Let's say, for example, receives a total of $80,000. Under a contingency fee arrangement, the attorney would subtract off the $50,000 that the landowner was initially offered. That's the landowner's. It's not subject to a contingency fee. The part that the attorney would receive would be out of the additional amount that the attorney was able to get for the landowner. Contingency fee percentages can range from 1/3 up to 40-45%, depending on when the attorney is hired by the landowner or gets involved. But under our scenario, let's just say it was a 1/3 contingency fee arrangement. So initial offer $50,000, final agreed amount to be paid $80,000. The landowner would receive $70,000, so $50,000 plus $20,000. The attorney would receive $10,000. So, what's at play for the contingency fee is the additional $30,000 that the attorney was able to get in addition to the initial offer that was offered by the pipeline company. So under that contingency fee arrangement, landowner receives $70,000, so $20,000 more than what they were offered by the pipeline company, and the attorney receives a contingency fee of $10,000. So under that arrangement, the landowner did not lose any of his initial offer from the pipeline company. There's also some scenarios, and I've seen this, and I've been hired under this fee arrangement as an hourly fee arrangement when the landowner believes that it's in his best interest economically to just hire the attorney on an hourly basis. And hourly rates of attorneys will vary just like contingency fee percentages, but attorneys can be hired, condemnation attorneys can be hired on an hourly basis. Some condemnation attorneys may not accept that fee arrangement. They may want to stick with a contingency fee. But once again, I've seen both arrangements. I've worked under both arrangements as well with landowners. So hopefully that's helpful in clarifying contingency fee agreements or arrangements for landowners in condemnation cases. Good luck.